Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. So today we're looking at some of the testimony from the Natalie Cochran case in West Virginia. And specifically, we're looking at the testimony of their expert forensic pathologists. Now, forensic pathologists are basically people who do autopsies and come up with cause of death and manner of death. Cause of death meaning the specific etiological reasons why, they assumed room temperature, and then also the manner of death being homicide, accident, undetermined, that kind of thing. So when you start out with an expert on the stand, the first thing you have to do is introduce him to the jury.
Sir, could you please state and spell your full name for the record?
Sure. Paul Shane Uribe, Paulshane Uribe.
And what is your occupation?
My occupation is a forensic pathologist.
And for our benefit, what is forensic pathology?
Forensic pathology is a specialty of medicine that specializes in unnatural, unexpected, or violent death.
Do you have any military experience?
Yes.
What sort of professional training do you have?
Professional training includes medical school from the Uniformed Services University of the Health Sciences, which is the military medical school in Bethesda, Maryland, a transitional internship, a residency in anatomic and clinical pathology, and a fellowship in forensic pathology.
And where are you currently employed?
I currently work as the Deputy Chief Medical Examiner at the Fort Bend County Medical Examiner's Office in Rosenberg, Texas, southwest of Houston.
The next thing you want to do is show that he knows what the heck he's talking about. So, again, you can rely on things like board certifications, among other things.
Do you have any peer-reviewed publications?
Yes.
Have you presented at national and international forensic conferences?
Yes.
And do you have any board certifications?
Yes.
What about active state medical licenses? How many of those do you carry?
I currently have 9 state medical licenses, all in good standing.
Are you a member of any professional organizations?
Yes.
And what might those be?
The National Association of Medical Examiners and American Academy of Forensic Sciences. I'm on multiple committees and working groups for both of those organizations. I'm also a member of the International Association of Coroners and Medical Examiners, the College of American Pathologists, which is the largest group of pathologists in the world, and the American Society of Clinical Pathology.
And sometimes it's really helpful to be able to say, well, what other big things have you done? What other cases have you been involved in that the jury might recognize?
Have you ever been involved in any high-profile cases?
Yes.
Just briefly, an overview, what kind of cases were those?
There were, let's see, my first...
And this draws probably one of the dumbest objections I've ever seen. He objects to relevance. And relevance is a very poor rationale here. You are trying to qualify this expert and show that he has the expertise to do that. And of course, one of the things that makes sense is, well, what other things have you done? So this was a pretty dumb and lame objection.
That question is irrelevant to these proceedings.
Your Honor, I would argue that if he were allowed to answer, they would be relevant cases.
Overruled. I'll permit the witness to answer. Go ahead, please.
My first high-profile case in the military was a group of Christian missionaries who were kidnapped by Somali pirates. This was back in 2010, 2011. I wrote the federal opinion for the George Floyd case, and I did a series of suspected insulin homicides in a VA hospital in Clarksburg, West Virginia.
So after you get through with all of that, and you've established the credentials that show this guy knows how the cow ate the cabbage, then the next thing you have to do is tender him as an expert witness. And you ask the judge, subject to cross-examination, 2, call him an expert witness. And that's exactly what happens here.
Your Honor, subject to cross-examination by the defense, I would ask that this witness be treated as an expert in the field of forensic pathology pursuant to Rule 702.
All right, Mr. Selden, do you wish to engage in voir dire pertaining to this witness's credentials?
No, Your Honor, we accept him as an expert.
All right, the court declares this witness to be an expert in the field of forensic pathology.
Now, you've established that he's an expert, but you haven't established that he's an expert in this case yet, because to do that, you have to show all the different things that he based his opinion on, because everything he based his opinion on is fair game for cross-examination.
Did you review certain records when preparing your report in this case?
Yes.
Could you briefly tell us which records you reviewed?
The records I reviewed were medical records from the Charleston Area Medical Center, Raleigh General Hospital, some hospice records, the initial autopsy report and autopsy photographs, and investigative documents, including interviews, investigative statements from police and other investigative officers.
So after they've done that and shown that he is indeed highly qualified, looked at all of this information, then we get down to, was exogenous insulin the reason that this guy died? And so part of that is to explain the biochemistry that goes into this. And of course, insulin is a hormone that every body produces. And when it produces it naturally and it uses it naturally, it splits off when it degrades into something called, I forget what the first one is, but the other one is a C-peptide. So you look for C-peptides, and you can look at that C-peptide level and you can determine whether it was insulin that came from the body or insulin that was administered to the body. And that's exactly what he's doing here. And it draws another one of those really, really dumb objections about chemistry. Huh?
When you administer insulin to someone, you have a lot of insulin, but no C-peptide, because that C-peptide wasn't cleaved off and wasn't relieved by the body, or wasn't released by the body. So when you suspect...
Your Honor, at this point, we have to object to this testimony. This witness is an expert in forensic pathology. Now he's testifying as to chemistry and other matters that go out of his range of expertise. This testimony is about chemical effects, and Dr. Krieger was the expert specialized in this area, not this witness. He's a forensic pathologist.
I think he's laying the groundwork, and I think it relates to his field. I'll overrule the objection. Dr. Uribe, you can continue.
Let me explain again why that was a really dumb objection. Because you don't get into medical school if you haven't studied chemistry. You don't get to pass medical school if you don't understand biochemistry. And more importantly, you certainly don't become a pathologist. And of course, it's the pathologists that are in charge in the hospital of all the laboratory testing equipment. So again, chemistry, all the different levels that are taken out, like potassium, sodium, that kind of thing, all fall under the pathologist in the hospital. So again, this guy would know that. And it's really funny here because the judge didn't even need any of the explanation from the prosecutor. He just said, "No, you're full of beans." So the next thing you have to do is you have to show, well, what kind of protocol do you use when you make these kinds of determinations?
Is there a typical protocol that you follow when you conduct an autopsy?
Yes.
Can you just very briefly, very high level, explain for us what that looks like?
Sure. So you never want to do an autopsy in a vacuum. So the first part, and sometimes the most important part, is review of the circumstances of death. You never want to do an autopsy in a vacuum and just like, here's a body, figure out why they died, because you need to know as much as you can about the circumstances of why they died. So the investigation, medical records, everything preceding when the person died. And then once you're doing the autopsy, it's broken up into several parts. The first part is the external examination, where you look at the body. You basically just describe what you see. Height, weight, eye color, hair color, evidence of trauma, evidence of natural disease, evidence of injury, things like that. Once you finish the external examination, you can open the body and do an internal examination. The internal examination, once again, looks for evidence of trauma, looks for evidence of natural disease. You take out the internal organs and dissect them, looking for evidence of natural disease, trauma, things like that. You can collect tissues or body fluids for additional testing or microscopic analysis. Once you've finished the external or internal examination, then you can, send for ancillary studies, which include microscopic analysis of tissue, analysis of blood or other tissues for toxicology to see what drugs were in, what drugs or medications were in the body at the time of death. And then you correlate all of these findings together, the scene investigation, the autopsy findings, the ancillary studies, and we use that to reach a cause and manner of death.
Then we get another dumb objection.
And so specifically, what is his manner of death?
Manner of death would be homicide, because there's no evidence that he administered insulin himself. People don't accidentally administer insulin to themselves or am given.
We object at this time. The statement that it is a homicide, that's for this court to decide. It is a conclusion that this witness cannot come to.
Your Honor, that is a manner of death which is determined by all medical examiners.
The objection's overruled.
And now our cross-examiner here manages to demonstrate two things at once. First, he demonstrates that he can't read more than one word at a time off his tablet. If I were the jury, I'd be like, yo, come on, man, I speak English. Let's go with this. Doesn't make a lot of sense to sit up there and ask questions like you're in a stupor. But he also manifests no understanding of what it's like to be a forensic pathologist. He asks, well, how many times have you testified for the defense? Well, in fact, many times he's testifying in ways that help the defense, even if they don't appreciate the fact that he was called by the prosecution. Because a lot of times in cross-examination, the forensic pathologist will give up anything that he has to give up. You just have to ask. So, but in terms of being called by somebody, he says about 20% of the time. Let's listen.
And I believe you said that you have done over 2,500 autopsies, and have you testified in an equal number of cases?
I've performed over 2,500 autopsies. I've testified approximately 40 times.
And of those 40 times, have you always testified for the prosecution in court?
No.
Sorry?
No.
No. About how many of those cases have you testified for the prosecution?
Approximately, it's about an 80-20% split. It's heavily weighted towards the prosecution because I'm often the medical examiner who performed the autopsy. So in a case of someone who got shot, I'm the doctor who performed the autopsy. I'm naturally called by the prosecution.
Now, in this final clip, we have another demonstration of the inability to properly examine an expert witness that is unfriendly to you. You don't want to let them get all of the information that hurts you in, and you also don't want to look kind of silly up there asking questions that really wind up hurting you. And I don't want to go too much further with this, but this again demonstrates a complete misunderstanding of what the burden is and what the standard is with respect to expert testimony, particularly in a medical case. When we put on an expert and we ask them, do you think this is malpractice? And they say yes. It isn't to a standard of absolute certainty, because there is no absolute certainty in science. Rather, it is to a reasonable degree of medical certainty. And that's the actual legal standard here. It doesn't have to be an absolute standard. But in spite of that, he asks this question.
Can you say with absolute medical certainty that exogenous insulin administration was the cause of Michael Cochran's hypoglycemia and death?
I can say with,
Absolute certainty, 100%.
I don't use the term absolute for anything.
Despite all of your assertions, you cannot accurately conclude that exogenous insulin administration is the cause of death, can you?
I don't believe that statement is true.
I'm sorry, I didn't hear your answer.
I don't believe that statement is true. I think you can, based on clinical correlation in the absence of any other viable explanation for profound or refractory hypoglycemia, hypokalemia, in the absence of any other causative finding for it.
So I have not been particularly impressed with either of these two lawyers representing Ms. Cochran. I don't think they've done a very credible job of denting the case here. And the lawyer here for the defense does show some understanding of the medical terminology, and he does show that he's tried very hard to do his homework. But in terms of actually nailing the forensic pathologist on anything, I don't think he did. And then when the prosecutor gets back up at the end of the cross-examination and cleans up anything that might have been, glossed over, the only thing she does wrong is not go back to the statement made by the forensic pathologist about the chart that the defense showed, because it was grossly inaccurate. And that was part of what I think that's one of the things that she should have done almost immediately. Because one of the things that the expert did, and you probably noticed this, is he answered only the question that was asked. A lot of times when you ask an expert, do you have any peer-reviewed articles? Well, yes, I put an article in the New England Journal of Medicine, and I put an article in Lancet, and I put an article in the Journal of Pathology, and I put an article in this publication or whatever. And they'll just start listing them off. But truthfully, that answer is non-responsive, because the next question should be, what are they? And then you can answer that. This guy does exactly what I have taught every expert I put on to do. Listen to the question, determine if it's a serious, reasonable question, and if it's not, explain why it's not, and then answer the question. And he did a marvelous job with this. Now, I don't think he necessarily had a great deal of jury rapport, because he did tend to be almost cut and dry with everything that he said. But in terms of jury rapport, the defense attorney has been terrible here. I would just be so off-put by what he did here with this examination that I probably wouldn't have paid too much attention to any points that he scored. That's what I have for you. Hopefully you found this interesting, and if you have, I would appreciate anybody who wants to comment on what they thought of the expert here. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.